Welcome back. This is Philip Bickle on June 24th, 2021. This is part 9. We are winding our way down to the end of the argument section. We have, I believe, 2 subsections left. And let's dive in. F. The totality of the actions by Judge Harry Freitas present clear bias and prejudice that prevented Defendant-Appellant from having fair proceedings and a fair trial. Judge Harry Freitas did not have any oral charges presented to him by Deputy Prosecuting Attorney Evan Smith, and he openly admitted during the December 15, 2016 hearing that he didn't even have a complaint with charges on it in his possession, as he attempted to elicit a plea from Defendant-Appellant. Official transcripts, let's see. So, if you really want to nail them on stuff that they do wrong with their speaking, you got to get those official transcripts. And if you're indigent, try to get them free. While on the record, when Defendant-Appellant offered to show him the letters and correspondence to the prosecuting attorney, who outranks the deputy prosecuting attorney, he declined. And at that hearing, Evan Smith was a deputy prosecuting attorney. He wasn't the prosecuting attorney, who is Mitchell Roth, who, like I said in a prior video, is now our mayor. Let's see. He also refused to dismiss the case that day, even though he had no charges provided to him to even consider proceeding upon. He ordered Defendant-Appellant to appear again on January 24th, 2017, and indicated a written motion to dismiss was due January 3rd, 2017, requiring the filing of a motion to dismiss before charges have even been entered is biased behavior and irregular process. He has no justification for this other than trying to keep a fish on the hook. This is far from impartial behavior. Judge Freitas ignored me when I entered multiple objections to being charged after the statute of limitations, and he entered a plea for me. So this is all documented. The transcript of the proceedings on the 4th of January 2018 on these pages shows how I entered objections and he just pretended like I wasn't there. Now this is a Hawaii Supreme Court site. The right to impartial judge adheres in due process clause of Hawaii Constitution. Part G. The totality of the actions by Judge Michael Udovic present clear bias and prejudice that prevented Defendant-Appellant from having fair proceedings. As was mentioned supra in Nilui, defendants have the right to an impartial judge as a matter of right. The actions of Judge Michael Udovic cannot possibly be seen as impartial. His bias and prejudice is a violation of the right to fair hearings. The record on appeal shows that on March 2, 2017, he scheduled a trial date, even though the ROA shows there were no written charges filed, and the official transcript for the arraignment day of December 2015, or December 15th, 2016, shows prosecutor Evan Smith failed to enter any oral charges. Judge Michael Udovic also required Defendant-Appellant to file a motion to suppress before any charges were ever filed. This is irregular process and a complete violation of due process rights. Alright, I think I might be able to knock this out. Let's go to the conclusion. For the arguments made above, I conclude with the following thoughts. The state prosecutors failed to charge me within a statute of limitations for the alleged offenses. I am entitled to the right to due process at all times. The trial court officers, be they clerks, judges, or prosecutors, have all repeatedly engaged in acts depriving me of this right. and some of them have acted in knowing collusion to do so, as the official video transcripts demonstrate. My most popular video, the cop, prosecutor, and judge busted, depriving me of due process rights. That one right there shows the three of them working together. The cop didn't know how to answer, so, from time to time he would make eye contact. You could see it in the video, indicating he didn't know what to do. And then the prosecutor would jump in, Brienne Larios. She would jump in and try to sidetrack things, and the judge did the same thing too from time to time. Like, the cop wouldn't even have a chance to answer, and they would jump in and say, "Oh, do you understand that?" And then it'd be like, "Oh, no, I don't understand that. Thanks for helping me out, Judge." But of course, these official video transcripts don't matter. The official transcripts do, the things that I'm citing in this. Don't cite videos and expect them to rely on that. You have to do media a certain way, and that's not something I've read up on or done at this point, but find somebody that has before you go down that route of trying to use video. It also has to be entered into evidence before you can use it in the appeals level. Or it should be, I would say. You might have been deprived of the right to enter it, and you could challenge that on the appeal too. Okay, enough tangents. I have been diligent in providing the trial court with State Supreme Court Law Library clerk certified records laying out the elements of process that the trial court and prosecution are required to adhere to, and this was ignored. The Deputy Prosecuting Attorney Evan Smith and Deputy Prosecuting Attorney Brienne Larios and Judge Harry Freitas and Michael Udovic all attempted to convince me that the police officer Clarence Davies had somehow brought lawful charges against me on behalf of the people of the state of Hawaii, in spite of the plain language law that I entered into the case record and referred to in my motion to dismiss for lack of all jurisdiction. This shocks the conscience, and that such a collusion would occur, all recorded on video. The list of outrages and violations of process is quite lengthy and appears to grow with each hearing. Judge Harry Freitas and Michael Udovic ruled a number of times contrary to the law and trial procedures, decisions that, combined with a bias toward me, deprive me of my constitutional rights to fair and meaningful hearings and due process of the law and a fair trial. Defendant-Appellant respectfully requests that this court, 1, order that the April 12, 2019 judgment entered by Harry Freitas of the District Court of the 3rd Circuit be reversed. And that's it for this. The rest is required elements for an electronic filing, such as the certificate of service. This is electronically filed right here. This is their electronic filing system, Jeff's. There's benefits to this, and there's aspects that aren't beneficial. So you might be able to file your claim, right up close to whenever the cutoff time is, on the very last day of, so close to midnight. It's not a good habit, but if you like proofreading stuff up until the end, you could take advantage of this. But it also makes it easier for them to serve you. In fact, it's all automated at that point, and if you're trying to get them on snafus where they're not doing every aspect of what they're required to do, you might hold off on signing up for this. I've got serious chronic leg injuries. My hamstring tendons were torn years ago, about 20 years ago, and they're permanently sore and weak and injured. So going to and from the post office isn't a luxury for me. Like, if I can do it, great, but a lot of times it can cause me injury, so I don't want to do that. So I eventually signed up for this. And also, I think at the appeals level, it tends to make everything easier. So that's it. This is the entirety of my appeal that's going on for the most popular video on my channel. And I hope some of you learned from this. Please post comments, questions, suggestions in the comments section. Give this a thumbs up and share it. And if you're not subscribed, please subscribe. I'll try to enter a bunch of the rest of my filings, and I don't know, maybe some of you can find it in your heart to use my email address listed on my channel site, Legal Tyranny, to make a few donations. I'll take anything, because 100% of this has come out of my pocket, and it's a hell of a lot cheaper doing this stuff pro se than hiring a lawyer, but it's not cheap when you're indigent, when you can't work for a living. So, you know, there's plenty of people out there begging for money right now, and many of them are actually controlled opposition, people that will try to steer you in the wrong direction on all sorts of things. I'm putting out stuff that I've actually filed, so, I got skin in the game here. And there's plenty of these legal gurus. They got no skin in the game, or they have absolutely no clue what they're doing. They just have a very strong heart, and they know what they're doing is right, but they're not going at it at the level where they're actually engaging in, what would be considered valid debate at the debate or argument there within the courts. So, of course they're going to get stomped when they go into the court if they do that. All right, that's it for now. Tune in for more later.